Well, hello. We're here today to talk about the selection of your business entity. That may not mean much to you now, but hopefully it means a whole lot more to you in a few minutes. So if you have started your own business or are thinking of starting your own business, there are some pretty big considerations on what type of business you're going to start. The choice is generally between just being yourself and hanging out a sign saying, hey, I do this type of work. That's considered a sole proprietorship. It means that you are the business and you are liable for anything and everything that the business does. That's not necessarily wise. The next type of business would be a partnership. Let's say you and your college friend want to go into business together. Well, again, if it's just the two of you hanging up a sign saying, hey, we're a business, you two are both liable for the liabilities of the business. That is, again, not the best situation. Another option would be forming a corporation. Well, a corporation is separate from you. It is a separate legal entity that has many advantages. It also has some disadvantages. We'll get into that. The other type of business entity would be a limited liability company. This is otherwise known as an LLC. They are incredibly popular, and many business owners choose this type of business entity because it is so easy to conform to what you need it to be. It is a separate legal entity which allows it to bear the legal liability for, or even the tax liabilities and things for your business. It has lots of benefits. The difference, though, between an LLC and a corporation when it comes to those tax liabilities specifically is that the LLC passes the taxes straight on to you. It does give you the opportunity, though, to have business expenses to offset those taxes, whereas the corporation bears its own tax liability and the owners only pay taxes on their dividends. So there's a complete separation of taxation with the corporation, whereas with the LLC it is considered pass-through taxation. I mention all of this because when you are forming your business, many people think that they register with the state of Michigan, they maybe get their tax ID, and they're off to the races. Well, there's a lot more to consider. First of all, I applaud you if you've done that. You have formed a business. You have chosen either a corporation or an LLC. Good for you. Over the next few minutes, we're going to talk about what that all means. But you also need to have an EIN number, an employer identification number from the IRS. It's one of the few things that the IRS gives you for free. But you need that. So then you can go open up a bank account. Having a separate bank account for your company allows you to separate assets. This is hugely important. When you have a business bank account that's separate from your personal bank account, you're separating what the company owns versus what you own. When you maintain this separation of assets and liabilities, so will courts. Courts will separate the liability. That way, creditors of the business can't necessarily come back after you individually and grab, say, your house, your car, your paycheck, your tax return, etc. Instead, they are limited to the assets of the company. But just having your company registered with the state, having an EIN number, and having a bank account is not necessarily enough. Let's talk about some of the other things that you need to have for your business. If you were to choose an LLC, and I'm going to focus on LLCs because they are 90% of the businesses that are formed by individuals and small businesses. When you form an LLC, it is highly recommended that you also have an operating agreement. The operating agreement spells out how your business internally works. It is a blueprint for your business. Many banks require an operating agreement before they'll even open a business bank account. If your business is looking for a loan of some sort, a lender will want to see, or at least know, that you have an operating agreement so that they know who is responsible for the company. The operating agreement has various parts to it. It will talk about what the rights and responsibilities and the expectations are for each of the owners of the business. It will talk about who the owners are. Is there only one or are there more? And what percentage ownership each of those owners has. It will talk about what the voting rights are for those members. If you are deciding to buy your building or lease it, do you have to get the consent of all the members? Or do you only need the consent of the majority of the members? It can also designate, say, a manager for the company. So then that manager is responsible for the day-to-day operations of the company, but anything over, say, $1,000 needs to be approved by a majority of the members, or unanimous vote, depending on the situation. Certain things are almost always unanimous. Voting out a member, admitting a new member, filing bankruptcy, closing the business, things like that are almost always unanimous votes. But you can choose how you decide those other issues. The manager can be given authority to do the day-to-day things, what color to paint the walls, which employees to hire, things like that, that don't require a vote at all. These are options for you. You don't have to have a manager, but you could. Recently, the Cannabis Regulatory Agency in Michigan has changed their requirements in operating agreements. It used to be that LLCs could be managed by the members, maybe a majority vote of the members. However, the CRA has recently said that LLCs need to be manager managed. That means that all those operating agreements need to be amended to add a manager. Basically, they're doing that so that they can do a background check on the person who's running the show. For you, you may or may not need a manager, but we can talk about that. Other provisions of an operating agreement that are crucial. What about a deadlock provision? This is crucial in any LLC where you have two members each holding 50% ownership. In such a situation, whichever member says no will win 100% of the time. Let me give you an example. Let's say that you would like to buy the building that your business is in. If one partner says no, well, he's got a 50% vote. It's probably not getting done. So the deadlock provision is a clause in the operating agreement that spells out how you resolve that dispute. How do you resolve the 50-50 loggerheads? Well, there's multiple ways to do it. One is to have a buy-sell provision, where basically one of the members gives a price and says, I want to be bought out for this amount. Well, the other side can either agree or disagree. But if he disagrees, he has to buy it for that amount. If he agrees, then he's selling for that amount. Another option is a modification on that, where the one who creates the deadlock sets the price, and then the other party decides if he wants to buy or sell at that price. Such a provision really encourages that the first person is setting a fair price, because if they try to undervalue the business, well, they just sold it at an undervalued price. If they overvalue it, then they're buying it at an overvalued price. Those are two easy provisions that can be put in. They also have the ability on preventing deadlock, because if there's a disagreement between those 50-50 members, they're probably not going to want to declare deadlock if it's something that's not that big of a deal, because they don't want to trigger that buy-sell agreement. There are other ways to deal with a deadlock that we can discuss, but that gives you an example of how it can be done. Another very popular one is that each member would name a tiebreaker, and then those tiebreakers pick a third tiebreaker, or the two members agree on a tiebreaker. That way there's a third vote coming into the mix, or more than three. That way it is not just loggerheads of 50-50 partners. You also need to think about deadlock could result in any vote that requires a unanimous vote. They don't have to be 50-50 partners, but if it requires a unanimous vote, one holdout could declare the deadlock. This is an important thought, because you could easily form your LLC with a, say, 51%, 49% ownership, and the 51% owner has the majority share and is winning the majority of the votes. But on certain things that are reserved for unanimous vote, there could be disagreement. Another provision that needs to be in every operating agreement is how involuntary transfers occur. An involuntary transfer would occur if one of the members were to die, or get divorced, or file a personal bankruptcy, or be disabled in some way. These are important provisions because each of these events introduces the possibility of an outside influence coming in to run the business. Let me give you an example. If there are, say, 5 partners in an LLC, all of them own, say, 20%. Great. They need majority vote to do most things. Fine. They're running along swimmingly. Unfortunately, one of those members gets divorced. Now, that's unfortunate for that individual, but it's also unfortunate for the company if it's not properly protected. In this scenario, the business ownership could be seen as an asset in the divorce. Now, I don't want to get too deep into divorce law, but do the other 4 members of the business want to be partners with the ex-wife or ex-husband, depending on how it goes? Probably not. So what do we do to protect that ownership interest so that it is not subject to division as a marital asset? Similarly, if one of those members were to file bankruptcy and a bankruptcy trustee gets involved and takes possession of all the assets of the member who filed bankruptcy, is he taking possession of that ownership interest, that 20%? I doubt the other 4 members want to be partners with a bankruptcy trustee. In these scenarios, you have an involuntary transfer provision. It basically says that as soon as a divorce is filed, or as soon as a bankruptcy is filed, boom, automatically you've triggered an event where the company is buying back those shares, buying back that 20%, or it's offered to be bought back by the other 4 members, or there is some provision that immediately allows for the company to protect those shares. We can talk about how you would like your company to be protected in those scenarios. Those are some of the provisions that are crucial in an operating agreement and perhaps you have never thought about. They are occasions that happen maybe years down the road after you've formed your business, but they are things that need to be considered. The difference, if you were to have, say, a corporation, the corporation is owned by shareholders. The corporation continues regardless of what's happening with the shareholders in their lives. It's a little bit different. The shareholders, the shares could go into a bankruptcy trustee, but it's only those shares. Now, are they controlling shares? That may be a different story, and we'd have to talk about that. Are they a director of the company? That, we'd talk about that and how that's affected by death or divorce. But these are all provisions that need to be considered and talked about between you and your attorney so that your desire and your wishes are fulfilled in your business, that your business is protected and is not subject to these unforeseen events. Further, as you form your business, you also have considerations not only of the liability, we talked a little bit about that, the taxation, we talked a little bit about that, but also governance. Let's talk about how your business is operated. We talked about unanimous consent. We talked about majority consent. We talked about a manager versus member managed. But let's talk about what your plan is for the business. As your business moves forward, are you looking to eventually scale your business? Are you looking to grow it exponentially? Or are you looking to pass it down to the next generation? We should talk about that because the governance of your business can be structured in such a way as to maximize one piece versus another. Let's look at this. If you are looking to retire and pass on your business to your children, you may very well want to set it up in such a way that you are training them for the next several years, that you are making sure that they can run the business over the next several years while you're still working. You can set it up where you are a consultant and getting pay as on payroll, and ownership is transferred to your children. You can set it up where it is structured over time, how they gain ownership over the years, and you are stepping down. That's one way of passing it on. Scaling your business. Well, let's talk about that. Do you have the funding to grow your business? Do you have the infrastructure to grow your business? Specifically, that infrastructure is, do you have the manpower to deal with that growth? Do you have the right people in place? whether it's on your marketing team or your sales team or on the workforce itself to manage the amount of business that you are looking to get? Do you have the funding source to get capital to make such a move? Also, how are you looking to do this? I have several clients who are looking to grow, but the question is how? Are they going to franchise their business? In such a case, we need to really put together a comprehensive book of their financials, of their liabilities, their assets, and that operating agreement comes back into play. We're going to need to include that along with multiple other pieces so that we could start a franchise. Or if we don't want to basically be selling off pieces of the business that are going to be operating somewhat independently but under our guidance, we may want to lease another location, and we are 100% in charge of now 2 locations. Or perhaps we want to buy another location. Given real estate rates and mortgage rates, I don't know which of the 2 is better right now, but we can talk about that. These are all ways to scale your business, all ways to grow, but all of them require you to have a firm foundation on how your business is structured and what business entity you have formed. I am happy to answer questions about what is best for you, but the reason that so many businesses are choosing LLCs is that they are easily malleable to what you need. Let me give you a couple examples. A corporation has bylaws rather than an operating agreement. It has annual meetings and sometimes even biannual meetings. It has minutes of its meetings. It has proxy votes. It has quorums that are required for votes, things like that. It has corporate forms that can be somewhat burdensome to a small business. Additionally, you are filing a tax return on behalf of the corporation, and then you are filing a tax return on behalf of each of the shareholders. Administratively, that can be taxing. No pun intended. The LLC, on the other hand, is much easier to manage. There are no required annual meetings. There are no required minutes. There are no required proxy votes. There are considerably less forms that have to be followed. Instead, it is spelled out in your operating agreement how notice is given to the different members, but you simply have a vote and you write down what was done. It's not necessarily the same requirements as the corporation. Taxes, you file one tax return for your LLC, and then your shares are reported on the K1 of your own tax return. Therefore, it's one tax return. It's much simpler. I mention this because when you form your business, it then projects you out into the future. And by choosing the right one, you can make your life a lot easier by choosing the right one at the beginning. Now, I do want to let you know that if you form a company, an LLC or a corporation, there are certain requirements that you have to be aware of. not only do you have to file taxes, but every year you need to file a statement with the state that basically says you're still in business and this is how you can find me. It's relatively simple. It's due by February 15th of every year, and the cost is relatively minimal. Additionally, I want to let you know that there is a new law that just went into effect in January that requires every company to also file a business owner disclosure. It is a new requirement that requires every business to fill out a form and declare who the beneficial owner of your business is. So if your business is owned by another business, which is owned by another business, etc., that's all fine. But this report requires you to come down to who is the individual or group of individuals who are responsible for those businesses. I mention this because even though reporting is something that many businesses do already, this particular one is new. It just started in January of 2024 and has some pretty notable pieces. First, if your business was started before 2024, you must file your report by the end of 2024. You have this whole year to do it, so please don't forget. However, if you started your business after January 1st of 2024, this report must be filed within 90 days. That means that if any of you started a business by registering it with LARA, with the state of Michigan, Licensing and Regulatory Affairs, if you filed that in January, this report is due in April. Please be aware. We'd be happy to help you with that report. Please don't miss the deadline though. If you miss the deadline, the fines are $500 a day and criminal penalties up to 2 years in jail and $10,000 in fines. I would not want that for any of you. What I would like for all of you is to be secure in your businesses, to start your business, to follow your passion, and to thrive. However, there are so many legal pitfalls, legal issues, legal areas that I do not expect you to know. I don't expect you to be an expert or to be aware of some of these issues. That's where we would be available to help you. That's where we come in to be that legal arm of your business, to help guide you to the right business entity, to help you with the operating agreement, to help you with buy-sell agreements, to help you with these mandatory reports from the government, to help you succeed and to free you up to do what you do best, to do your business and to succeed.